Okay, hey, welcome everyone. I'm Michael Antozzi. I'm the Director of Practice Growth Consulting here with MyAdvice. And today we have a very timely and important conversation for medical spa owners, wellness practice owners, healthcare professionals. You know, the use of GLP-1s in practices, they've really have skyrocketed over the last few years, and both in the aesthetics as well as the wellness spaces. And so while that offers some good growth opportunities for practice owners, it also raises some very critical legal and compliance questions. And so to help us navigate, and especially this ever-evolving landscape, just even of a few weeks ago, I'm joined by my friend, Sarah Schickman. She is the managing partner over at Lengea Law Firm. Sarah is a leading healthcare attorney specializing in medical spa structures for their businesses, helping them to stay compliant, helping to mitigate legal risks. So, Sarah, thank you so much for being here today. Before we dive into some of these legal considerations about GLP-1s, can you just give our audience just a quick little background on yourself and some of the work that you do to help our practices?
Yeah, definitely. And thank you so much, Michael. It's a pleasure to be here and help your clients. So about me, I have been in the med spa space since 2014. I actually used to co-own a med spa chain with 12 locations. So I know it from an operator perspective as well. I've been a lawyer since 2007 and started this law firm basically because lots of med spas would always come to me asking for legal advice. And so I love helping people, and it's really a pleasure to be able to assist in any small or big way. So thank you.
Absolutely. And for those of you who are watching this, Sarah and I are actually going to be presenting next week at the LAMCA meeting. Sarah's actually, I believe, giving two talks as well, too. So if you're going to be in the
Mhm.
LA area, please swing by Beverly Hills. But anyway, getting back to the GLP-1. So Sarah, talk to me, what are some of the most recent legal changes that can impact the ability of these practices to offer GLP-1s?
Yeah, so previously, there was the ability to compound generic versions of brand name medications in the GLP-1 space. So before, as long as medications like Ozempic and Mounjaro were on the shortage list, people were able to compound those to be able to essentially offer copies of them that are generic. And that was able to be done by compounding pharmacies. Well, as of last week, the FDA has removed the brand name drugs from the shortage list. And so what that means is when a drug is removed, you can no longer compound it. And these compounding pharmacies have a deadline to comply. So depending on what type of compounding pharmacy you are getting your medications from, they have a different deadline. One deadline is April 22nd, 2025, and one is May 22nd, 2025. But both are, coming up right in a matter of months. And after those deadlines, the compounding pharmacies are not supposed to make copies of these drugs anymore. So they can still make drugs that are similar but not copies. So, for example, by adding other ingredients to the compounds, by doing different strengths of the compounds that are not offered in the brand name form. However, that may not fly with the big manufacturers. So even if a compounding pharmacy offers you these drugs after the deadline, that doesn't mean that that practice is going to be compliant or that they'll protect you if you get a cease and desist from Novo Nordisk or Eli Lilly. So I think what's the thing to think about is to be protected against these big pharmaceutical companies coming after you, not so much the FDA or the compounding pharmacies, but more that they are these big pharmaceutical giants who've spent billions of dollars developing these drugs, and they're trying to protect their market share, and they don't want anyone competing with them. And so they're going to go after people very, very aggressively.
So, in practical purposes, then, are you saying that practices that are offering GLP-1s can only offer them through, say, Novo Nordisk or through Eli Lilly and the drugs that they create? Is that what you're saying?
Yeah, the most compliant way after May 22nd of this year of 2025 will be to for med spas and other practices to place their orders through these brand name manufacturers. Um, Getting them through compounding pharmacies will not technically be allowed. And so it'll just be like a little bit like a ticking time bomb. Like I'm sure on day one, there is not going to be a lot of enforcement against this, but eventually there's going to be a big legal risk with getting into a fight with a big pharmaceutical company. So I think weight loss programs have to be restructured a little bit. I think there's still money to be made, but in a different way. Whereas right now, a lot of people were offering just weight loss and then getting those drugs from the compounding pharmacies. Now, maybe it could be a whole weight management program where, let's say you're charging someone $500 a month, 250 of that or so is going to the brand name manufacturers for their product. And then the other is for you to do other things with the client, like nutritional coaching or maybe some body contouring procedures. And I think Michael's firm can help people design those kind of programs and market them, but I do think they'll have to change.
No, for sure. It's very much a fluid environment right now. I mean, we're seeing this a lot with some of our wellness practices as well too that are offering that. So this is really, really sound advice. I'm curious to know, Sarah, with in terms of you mentioned like changing out some of the structure. So when we talk about like the business structure, can a non-physician owned med spa can they legally offer GLP-1s, or what type of like business structure do they need in place to even offer these drugs?
Great question. So that depends on the state. So in some states, like Florida, that don't have a prohibition on the corporate practice of medicine, a med spa doesn't have to be owned by a physician. So in those states, yes, those med spas, even if they're not owned by a physician, can offer medications. But in other states like California, Texas, New York, and many others, to properly administer drugs and order medications and be a med spa, you need to have the right legal structure. And what that means in those states is a structure called an MSO and MSA. So it's not impossible for a non-medical person to be involved in this field in those states. It just has to be structured very differently than it would have to be structured in a state like Florida.
One of the things I've learned about, your firm is that you actually have folks that are really constantly keeping a pulse on the state laws and regulations and how that might vary from one region to another region. And most importantly, like the frequency of how those laws actually can change.
Yeah, I mean, it's crazy how the pace of change in everything these days, right? Not just the law, but like the amount of new products that are coming out all the time, the amount of HR regulations that are changing all the time, like how some states are adding mandatory maternity leave, and some states are saying non-competes are illegal. Some states are saying non-competes are illegal for only healthcare professionals. So I think there's a lot of change happening super quickly, and the expectation is that everyone will understand the changes and comply with them immediately as they happen. So a lot of times people may say, well, I didn't know, or I didn't read, or I didn't understand. The regulators don't have a lot of soft spots for those kind of excuses. They're more like, okay, well, you should have talked to an attorney, you should have researched the law. So it's important to either you yourself become proficient at knowing the law of your state, which I think is hard. It's like me becoming proficient at, doing people's Botox, right? Like it
Yeah.
would take me years and years, and I would have to become a nurse or a doctor. So it's much better for me to just go to a place where there's an expert and they can help me. And it's the same thing with the law. This is what we focus on. And yeah, we have people on our team whose only job is to research the law all day long, every single day.
So talk to me about the medical directors. I mean, so many of our clients, they have, medical directors that, just kind of hang their shingle on the wall, but they're not actually working there inside the walls of the practice. So what role do medical directors actually play in compliance? What liability do they have when a practice might be administering GLP-1s that they're a medical director of?
It really depends on the state, and really depends on how much enforcement is in a particular state on this area. So some states kind of take a laissez-faire approach, maybe because the government is understaffed, or maybe because it's not a priority. So in some states, it's okay for a medical director to be somewhat detached. Legally, the requirement may be that you have a medical director and that they're in every state to supervise something, they have to be competent in that procedure. So if your medical director does not know themselves how to do GLP-1s or the basics of GLP-1s or the basics of Botox, and they're supervising you doing that, if there's ever an issue like a malpractice claim, a board investigation, one of the things they're going to ask for is to swear under oath about this person's training and to provide their training certificates. So you should have a medical director who's competent in what they're supervising. Otherwise, how can they competently supervise? Some states have requirements like about distance of the medical director or board certification. A lot of states don't. So a good rule of thumb is have a medical director who knows the procedures that they're supervising, that is involved in your practice at least on a monthly basis, at least via a phone call, where you have a record of them speaking to you and discussing, what's been going on and how you're doing and any complicated cases. That would be like the bare minimum, I think, in any state. And then what's the liability? The liability is, in general, liability flows up. If there's ever a problem or a lawsuit, typically the medical director will be one of the people named in the lawsuit, even if they were a totally off-site medical director. And they're going to have to explain how they were in charge and how they were good procedures and how everything was followed. So the more paperwork they have, the more written policies and procedures they have, and the more certifications they have themselves in these treatments, the better protected they are.
I think that's one of the things as well. So from my understanding that you offer for your practices is actually like frameworks or documentations to create these protocols. Is that correct?
Yeah, so as part of our packages, we have either templates for these protocols or customizations of them, depending on what people need. But yeah, absolutely. Because if there's a legal problem, the number one thing that protects you is the paperwork. So, and a lot of times when people call us after a problem already happened, like after a board investigation or a suspension or things like that, or a malpractice claim, we're always going back and reviewing what paperwork is in place and trying to make it better for next time.
Fantastic. Sarah, you've given us our audience really some great nuggets here. So I really, really appreciate your time. How can folks find you? How can they get in touch if they're, wanting to question anything that's happening, if they're offering GLP-1s at their practice, if they have some follow-up questions, or maybe if they're even needing some guidance on how you might be able to help them just with setting up their whole business infrastructure, protocols, things of that nature. How do people find you?
People usually find us on our website, which is www.lengealaw.com. And right on our website, we have a link to schedule a free consultation with us. And that's the easiest way. We're also on Instagram at lengealaw.com, and on Facebook and on YouTube. But most people find us on the website, and there's a link to schedule a free consultation. And I think you guys are putting it in the video too.
Yeah, we're actually pulling that up right now. We're putting a QR code. So folks, if you're wanting to schedule a complimentary consultation with Sarah and her team, below is the link to schedule that. I'd encourage you to take out your phone and get some time to connect with her firm. So Sarah, thank you so much. We really appreciate your time, and I know you're very busy. So just taking a few moments here to give our audience some understanding as to what's been happening in the GLP-1 space and the changing environment is very, very helpful. So thank you.